respect this matter. Mr. Hamilton, you want to just make a very short argument? I read your motion. I've also read the opposition, so just go ahead and make a short argument in respect to your motion to strike.
Thank you, Your Honor, and thank you for the opportunity to appear remotely. And just for the record, Bradley Schrager, local counsel, is on the line as well, and my partner, Mark Elias, is as well. Mr. Cancel's supplemental declaration should be rejected for three different reasons, Your Honor. First, it's untimely. Expert disclosures are to be accompanied by a written report. At the time the disclosure is made, Your Honor set that deadline for last Friday. There was no such supplemental report filed. In fact, it was not even produced to the defendants until after the deadline for filing all of the evidence to be considered by the court here today. So for that reason, it should be excluded. Number two, and we've addressed this in some length in the trial brief, Mr. Kemsall is not a qualified expert by any stretch. He, by his own admission and is physically demonstrated in his CV, he has spent the majority of his career working for the Republican National Committee as a political operative. He has never taught, has no advanced degrees at any college or university, is not familiar with scholarly use of statistics, and in fact didn't do most of the mail work himself that underlies this analysis. And finally, Your Honor, and for the third reason, the declaration is simply irrelevant and unreliable because it has no sound methodological foundation, and by its own admission, the supplemental declaration falls far short of satisfying the requirements that might allow it to be admitted. There's a matching between certain files produced by the Department of Motor Vehicles and voter files, but even he admits that it's only matched on part of the name. So a single member of a household could be a non-U.S. citizen living with several other U.S. citizens, and Mr. Cancel has no way of distinguishing between any of them. So for all three reasons, Your Honor, I think the declaration, supplemental declaration, should be rejected by the court.
Thank you, Your Honor. May it please the court. Jessica Knoll on behalf of the contestants. The motion to strike should be denied for the reasons that we laid out in our filings on this matter. As to the specific positions just laid out by the defendants, I'll also start on the timeliness of the filing. The information that this was based on, that Mr. Kamsel's supplemental affidavit is based on, is data that was retrieved from the Department of Motor Vehicles at about 2:00 p.m. on Monday, pursuant to a subpoena. This is one of the few instances where it's data that was discovered not by extrajudicial discovery in our case, but actually using more of a formal discovery process, because that's the only way we could receive this information. And as soon as we received this information, it was passed along to the data scientist for comparison with the list of people who had voted. What we, of course, learned then is that approximately, it appears from the expert report, about 4,000 non-citizens voted in this election. 4,000 additional people that are not authorized to vote in the 2020 election. Mr. Kim?
What about the court's ruling and order that basically all witnesses had to be disclosed by the contestants by 5:00 on November 25th, 2020?
Your Honor,
I understand something comes up, and I understand things would cut up, but is it fair to the defense and suddenly to bring this in at the last minute?
Your Honor, it was information that there's no other way that we could have gotten it, and there's the idea that you always seasonally supplement, and that's exactly what we did in this case. This litigation is especially truncated, and it has to be that way, and we understand that. But data that there's no way for us to have had at that deadline that the court set That's why the court has discretion in these situations to say that since there's no possible way that we could have had this information by November the 25th, there's no way that we could have produced this specific information. We did tell them that Jesse Kamsel was going to be a witness in this case, and indeed, he did give deposition testimony in this case. He gave deposition testimony in this case on other data information that came out within, I think, about, at roughly the same exact time as this information was produced to us by the Department of Motor Vehicles.
What about the requirements of
NRS 293.415, that basically this matter be heard upon deposition and argument. They have no ability, basically, to cross-examine him on this new additional material. No ability at all to question his methods or methodology in respect to that new material. Is that fair?
Your Honor, I understand the court's position on that, and I would say that the better remedy that would meet the interest of justice on this is to allow them to do just that after argument, to allow them. We can do that tomorrow. We can do that, this evening, and then we can submit the deposition supplementally to the court for its decision. That would be something that could meet the interest of justice to still allow them to cross-examine Mr. Kamsel on these issues without denying us any reasonable means of bringing this to the court's attention, since there's no other way that we could have gotten this and to submitted it to them any earlier. We literally submitted this at the earliest moment we could have in order of getting the data, comparing the data, producing a very short report explaining how the data was compared, and then providing it to the defendants. They should have the ability, but they certainly have the resources available in a document subpoena situation to use their own experts, their own resources to compare this data and say if they think that we got anything wrong, that it's fewer than 4,000 non-citizens who voted in this case. They haven't done that yet. They've had, at this point, a similar amount of time that we've had to do this, and they haven't done that. But if they want the opportunity to depose Mr. Kamsel on that, we'll make him available for a deposition, a very short deposition after this. We can submit it to the court supplemental without further argument.
Mr. Hamilton, any final comment on this issue?
Your Honor, took the words out of my mouth. The statute anticipates evidence to be presented by deposition and the argument of counsel. That hasn't happened here. This contest was filed on November 17th. That's quite a while ago, and counsel had plenty of time to secure whatever data he needed and to produce the declaration or expert testimony. Your Honor gave clear deadlines. If there was some issue, then counsel certainly could have filed an emergency motion for the court to leave or even approached us for how to deal with that. He did neither. The court has indulged counsel at every turn by providing ample opportunity for discovery, but this is both inconsistent with the statute and fundamentally unfair to the court and to the defendant. So we would ask that this
The order of the court,
Go ahead and strike the supplemental declaration of Jesse Kamsel. I believe for the reasons I clearly indicated stated, one that had a disclosure deadline of November 25th, 2020, which I might add, none of the other experts cited.
Things were even disclosed on that date. They were all disclosed later. I don't know about disclosure, but the reports were not done until November 30th, I believe, in respect to that. But I don't allow all that. Not striking anything other than this current declaration for two reasons, primarily. One, its way, two, primarily under NRS 293.415, clear to this court that I have basically limited depositions and argument in respect to making a determination in this case. Regards that, the reason for that, clearly in the court's mind, ability to cross-examine and verify the information and make sure basically it's fair to both sides. So, that in mind, I want to move forward in respect to that. It's my intent to give each side approximately an hour. We may take a break somewhere along the way in respect to this matter. In regards to that, you can reserve part of your time for rebuttal. decide, you have an hour. Want to go 30 minutes and reserve your time, that's fine with the court. However you want to do it, respect to that, fine. I do have one other question that the court thinks is important to start with, and that is, what is the evidentiary standard that applies in respect to this? I think it's important that we go through the evidence and look at the evidence, that we understand what the standard is that we're going to apply. Is it a clear and convincing standard, or is it a reasonable doubt standard? So, given that, and all, that you want to comment on that? Yeah, just short. I've read all the briefs, and that's short. I'm not making a decision which way. I just kind of want to give a flavor for everybody and what the course we're going to look at.
And I understand that that would be an important point for the court to consider, is because the statute itself is silent on the standard of proof that would be required in a case like this. The defendants have cited law in other jurisdictions, but of course, since this is a creature of statute in Nevada, it would be more appropriate to look at how Nevada handles situations like this. The default is always, in a civil case, preponderance of the evidence. That is the default burden in a civil case. And this is a civil case. It's an unusual case, and it's understandable why there wouldn't be a lot of case law defining some of this. But short of any intent of the legislature, and we're aware of no other intention of the legislature to increase the burden of proof to a clear and convincing standard, as the defendants urge the court to do, the right thing to do is go back to the civil standard that we are very familiar with, which is preponderance of the evidence. From a policy perspective, that's the right answer too. We are trying, as the court said when the court took the bench, to determine whether every vote was properly counted, every legal vote was counted in an election like this. There is no reason to give more deference to one side or the other in that determination. The proper thing to do is to weigh the evidence to see whether or not the decision to certify the electors for Vice President Biden was appropriate. And so consequently, since there's no reason to favor the defendants more or the contestants more, the preponderance of evidence standard is the appropriate use here.
What about NRS 293.410, which talks about reasonable doubt? It uses kind of a reasonable doubt throughout that, and it talks about reasonable doubt. Is that similar to preponderance of evidence, or is that a little higher standard?
And that's an interesting use of reasonable doubt in that statute, because it's not the reasonable doubt, very clearly, that we'd be used to in a criminal case. It could be read to say that it could be read to offer a standard much more favorable to the contestants, quite honestly, of saying that if there's a reasonable doubt in the outcome, that the contest should be granted. It's difficult to see exactly how that would work in the civil setting, Your Honor. And that's why I think it's more appropriate for me, and quite honestly, hopefully, it gives me a little bit more credibility to you to say I don't have to just throw up as somebody sitting on this side of the courtroom who has a burden, some burden, that I just have to have almost like a probable cause type standard. I think it does have to be more than that. It has to be that we do have a burden to meet here, a burden that we will meet, that we're very confident we will meet. I think the way a reasonable reading of the reasonable doubt language in 210 means that it's similar to the preponderance of the evidence standard that otherwise the court would use in this setting.
Mr. Hamilton?
Well, Your Honor, I agree with counsel to the extent that the Nevada Supreme Court has not yet defined clearly the burden of proof required in an election contest. But an election contest, by its nature, is asking a court to do an extraordinary thing, which is overturn the results of certified So we have to look at, I submit that two things guide the standard. First would be how are election contests treated elsewhere on similar statutory schemes, and that is they use a higher, clear and convincing evidence standard. Second would be more of a functional approach. The cause of action sounds, at least in part, in fraud. And fraud under Nevada and the law of virtually every state requires a higher evidentiary standard. So for both reasons, I think that the clear and convincing evidence standard is the one that should be applied by the court here. Ultimately, and I know you don't want me to argue the rest of the merits of the case, ultimately I'm not sure that it's positive here because I think the claim fails under even a more relaxed preponderance of the evidence or reasonable doubt standard, Your Honor.
Well, I would reserve ruling on that issue. I think it's kind of a difficult issue in regards to this.
And it may or may not make much difference in getting down the road. The other question I have is there was a certification of the election results by the Nevada Supreme Court. Does that have any impact on this hearing? And again, if you look at the statute and the timetables that things have to be done under Nevada law, and you do have time periods in which to file a contest and was filed properly within the time period. So I'm not sure it technically has any impact. So just a final comment.
Your Honor, I think that's a very good question, something that we looked at.
I always like to hear that. I ask the very good.
It's a good question from the very nature of the fact that came from the bench, I know. Your Honor, the contest statute is I think, quite clear about the timing and the fact that the ministerial action of certification by the Secretary of State and then the governor does not take away the court's ability to enter an order on a contest. Of course, just by the timing that the General Assembly has laid out on that, I think is very clear. And up until, matter of fact, the law actually is that you can see from the legislative history on the contest statute that it is anticipated that the timing has to be so truncated because no one is able to take the oath of their position until the contest is decided. And so that is the important time frame to look at for the contest position, is to actually go down to the legislative history. If we haven't cited that, we can get that and provide that to the court. That the important thing is whether they've taken their oaths to actually then begin their terms, and they can't take those oaths until the contest is actually decided. And so that would be separate and apart from the certification process by the Secretary of State. Otherwise, the timing laid out by the legislature just would be impossible for there being an election contest at all. It would render the entire statute a nullity.
Thank you. Mr. Hamilton?
Your Honor, I think Nevada law speaks to that in NRS 23417, sub 4. Whenever an election is annulled or set aside by the court, and the court does not declare some candidate elected, the certificate of election or the commission, if any has been issued, is void and the office is vacant. So I think, without having spent a lot of time thinking about it, that the action by the Nevada Supreme Court does not prevent this matter from going forward to a judgment.
Thank you. I agree with you.
I agree with both of you. Thank you in respect to this matter regarding to that. So at this time, basically, the court is prepared to go ahead. Now, if you want to start with the argument, again, we're kind of limiting everybody your time. You can reserve whatever time you want. The law clerk is keeping track. She's very diligent at this, so. And I want you to know that I've read all the briefs.
up to the brief, up to that, and I read as much of that as I possibly could from 5 o'clock until noon today in respect to that. And
There's a significant amount of pages there, but I concentrated primarily on what both counsel know. I read primarily the depositions of the experts in regards to this particular matter. Spent a good deal of time going through that, and I felt that was probably one of the most important places to start. So with that, go ahead.
But, Your Honor, we understand that there's a substantial amount of submissions in this case. In a very truncated position to get it all forward for the court, I was reminded of the old adage that if I had more time, it would have been shorter. In this case, we think that almost everything that we have given to the court is something that is important for the resolution of this matter. It is all critical information that we've been able to gather in a month, and we appreciate the court's consideration of that and taking up all the time that the court has in looking at everything. We are actually also just put together something this morning that we thought might be helpful, and that is an additional exhibit index that gives the particular exhibit and which binder it's in for our binders. Can we hand that up to the court?
Yes, absolutely.
Okay.
Thank you very much.
Thank you. And we will make sure that we get one of those to opposing counsel promptly as well, if it hasn't already. Your Honor, I'm going to go for about 35 minutes right now, and then I'm going to withhold the rest of my time before rebuttal, if I can do math. This case is about the failure of the electoral system in one election. And no one ever wants to say that, but it's true. The evidence proves it. The questions are, how did this happen? Who's responsible? And what do we do about it? Our free, fair, and open elections are a source of national pride. We spend untold millions of dollars around the world preaching the benefits of election integrity. We make sure that elections are decided by the people who vote in them and not by outside actors trying to influence the results. Voters who are the ones that are legally able to cast those votes, and the importance that every voter gets only one vote. The evidence that we have submitted is compelling. It shows that election officials planned and implemented an election system that would be highly susceptible to fraud, that it would ignore the best practices developed over the years, and eschew meaningful observation. This was made worse, as Mr. Gessler's expert testimony makes clear, by the legislature's decision to adopt AB 4 and take us to a system of universal mail voting at very much the last minute, without a sufficient amount of time to clean the voter rolls and implement a plan to ensure voter integrity.
Let me ask you about that, and that's
basically the vote counting machine, the counting machine that they did in respect to the ballots. Is that correct?
Are you talking about the Agilis machine in Clark County, Your Honor? Yes, Your Honor.
Wasn't that issue determined by Judge Wilson in the Cross case and the other cases that have been filed throughout the state of Nevada? And I'm raising that because the defense raised an issue of preclusion, and we're going to get to that at some point in time. And that I basically on issue of preclusion, is that something I should even consider?
Your Honor, I think the clearest answer, or the reason why the answer is no, is that Judge Wilson decided that there wasn't standing to bring that challenge. And anything decided without standing is a nullity and can't have preclusive effect. There were other reasons for his decision, but because since we would be looking, well, regardless if we'd be looking at issue preclusion or claim preclusion, the lack of standing would be dispositive on that particular issue. You also do have the fact that the parties are different between the two contests, and so for res judicata purposes, that would have an effect. And one of the reason that standing was so important and why you wouldn't have a res judicata or collateral estoppel issue come up here is because essentially the argument wasn't right yet. We didn't know at that point if it was going to be a problem. And so you can't really say on one hand, well, we don't know if this is a problem yet because it happened pre-election, and so the election actually comes, we see it is a problem. And then say, well, it's already decided when it was said it wasn't right. That kind of reasoning doesn't really work for a preclusion narrative. So the primary issue that we're going to see with the use of the Agilis machine here is one that's purely statutory. As far as the legal problem. And then what flows from that is going to be the evidentiary problems, which there's not going to be the preclusive issues on the evidentiary problems, because even if the Agilis machine had already been determined to be legal by Judge Wilson's previous ruling, the issues at play is whether the authenticated signatures, whether they were authenticated by a human or by a machine, whether they were properly authenticated, whether they let through fraudulent votes. And we do have evidence that we've submitted to the court that says that the answer that we've been able to determine without really any use of civil discovery, and certainly not what you would normally get in a fraud investigation of this sort, is that yes, the signature verification system, machine, human, whatever, let through bad votes. So the statutory issue is going to break down, and I don't want to, well, we're there, so I'm just going to address it if it is easier for the court. The statutory issue is that even in AB4, which is, of course, just passed this past summer by the legislature, it decided, it required that signatures be verified by the clerk or the clerk's employee. Clark County is a little bit different because there's a county statute that specifically says that the role of the clerk is assigned to the registrar when it comes to election matters. And so that statute, for Clark County purposes, which is the only places that uses this Agilis machine, means that essentially the registrar of voters or his employee has to verify those signatures. And then it says there is another statute that says, I think it's section 25, that says that, I might be wrong in that, that computers can be used except as otherwise provided for. So this is one of those specific versus general and exclusio unius, expressio unius. I'll try to remember my Latin on that, but when you name one thing of the similar category, things of a different category are necessarily excluded. So using our statutory construction canons, we see that the legislature for signature verification specifically wanted to exclude computers being able to do that work by requiring it be the registrar / clerk or an employee. This makes sense. It makes sense that knowing that there would have to be this signature authentication process with universal voting in AB4, that they would want to have, which ended up not happening, a robust signature verification system and process. So that's why, if you look at the statute, it's very clear that this cannot be done by computer. It had to be done by people. So aside from any of the other factual issues with the machine. Just the very nature of the statute means that it was improper to use it to authenticate signatures, especially for the fact that you had universal voting without really cleaning the voter rolls sufficiently beforehand. The preclusion issue there, since the decision before wasn't right, there was no standing, the parties are different. There is no preclusion here, and that is still proper for the court to consider. Hope I've answered the court's question on that.
Sure, thank you.
Thank you. Having that time to clear the voter rolls and implement that plan for election integrity and ballot integrity, it became a real problem in this election. And it was not an unforeseeable problem. It was a problem that people were making clear all along, that there was going to be issues if we didn't take robust efforts in order to make sure that every voter was only voting once. As a result, there was a system that was ripe for the picking when it came to fraud. And the fraud came. I need to address the elephant in the room. There's a narrative that everybody here has heard. It's a narrative that's been repeated in the media time and time again, traditional media, electronic media, social media. It's this beating of the drum saying that there's no voter fraud, there's no widespread voter fraud. It seems that if people think they say it often enough, it will make it so. They just say it simply doesn't exist. And they chalk eyewitness testimony up to one-offs. Sometimes they just ignore evidence completely. They also ignore the fact that fraud cases usually are prosecuted when it comes to something like voter fraud. Oftentimes, it might be a federal prosecution, state prosecution. Gets investigated by law enforcement for months, years. The prosecutors go in with grand jury subpoenas, the FBI subpoenas for documents. And they are able to have the full availability of almost whatever evidence they want, as long as it's not subject to some privilege. And over a long amount of time of doing that, they can actually bring in a case for voter fraud or for any other type of mail fraud, wire fraud, fraud for getting people into colleges, whatever it might be. In this case, what the contestants have done is 1 month ago was the election day. In that short amount of time, using few resources, some very dedicated people, they have put together a robust body of evidence showing the voter fraud that came in this case. They did it without the discovery tools that are normally used in civil cases, without law enforcement support, and unfortunately with a great amount of obstruction and stonewalling from people who should have known better. And the contestants developed in that time specific evidence of widespread voter fraud, enough to account for up to about 4 times the deficit between the two candidates for president. And when we look at the when we look at fraud and what needs to be proved, and we can call, I mean, some of this is just outright fraud. Dead people aren't voting of their own volition. It just doesn't happen. People don't accidentally submit 2 votes. It's difficult to see how it would happen that somebody would innocently submit 2 votes. And some of them are, perhaps we can call them more irregularities that should have been accounted for to make sure that the system had integrity, that it, regardless of the intent of the individual voter, regardless of the intent, it was improper for that vote to be counted. For instance, you only get to vote if you're a Nevadan. And that means a Nevada resident. And if you move out of Nevada, the statutes in Nevada have a very specific purpose of what you do. Now, I myself might feel like a Nevadan at this point. I've been lucky enough to be with Nevadans for the past almost 7 weeks of my life, which has been great. And it's been very gracious for this court to allow me to appear before it pro hoc vice. But I'm not a Nevadan. I'm a Virginian. And as much as I might rather pay Nevada taxes and vote in a swing state, I have to do that in Virginia. Just because people may want to vote in a swing state, and because they might have once lived in Nevada, and maybe they still have family in Nevada, doesn't mean they get to do that. So, regardless of whether they know that particular law or not, we're normally with fraud, we go back to those elemental definitions where there's that level of intent that's involved. That is an improper vote. That is a vote that is irregular, that should not have been counted. That we have ways to make sure that the voter rolls are clean, to make sure that those people, once they have moved out of Nevada, are no longer voting in Nevada's elections. So this body of evidence, these data, this information that we have given and presented to the court, shows that there is a large number of sometimes outright fraud, and sometimes these irregularities, however you want to categorize them, that both result in the same outcome. They're votes that shouldn't have been counted. They shouldn't have affected the results. This is especially important because every time you have a fraudulent vote that is cast, an improper vote that is cast, you have just canceled out the vote of a legal voter. You've disenfranchised a legal voter. And the more fraud, irregular votes that are counted, the more Nevadan voters you've also disqualified them from voting, disenfranchised them from voting. And the facts before this court that happened in Nevada, not anywhere else, everything that we have that we can show that happened in Nevada, point to many, many thousands of votes that were improperly counted, which means many, many thousands of Nevadans whose votes were disenfranchised. Of course, much of the evidence of voter fraud is in the hands of government and election officials. And as I mentioned, we've had to do much of our work with using hard work, some elbow grease, and problem solving in order to get the evidence that we need without the normal civil discovery methods. As a litigator, it's been a challenge. It's been somewhat rewarding to think outside the box for how you get information to present to a court without being able to send out document requests and document subpoenas early, and interrogatories and take depositions all through a long period. We of course, in this case, we filed it on November 17th. Last Tuesday, the court gave us the green light to start the discovery process with the depositions. We could, in almost all of our depositions, were of our own witnesses. The only subpoena that we ended up getting from an outside party returned for documents, I believe, one of the only ones was from the Department of Motor Vehicles. Almost all the other evidence is stuff that we were able to gather ourselves in that time frame, which was why it was particularly troubling that other evidence that we knew was there, it was hard to get in time to present to this court in a timely way, being the limitations of what we have available. We can't just go knock on the government's door and ask them for that information without some sort of legal tool. An example is that when the court gave us the opportunity to start discovery, we promptly got out a subpoena for the Registrar of Voters in Clark County, Joe Gloria. They closed and locked their offices so that we couldn't serve it. We tried to serve Mr. Gloria personally in his house. He spent several days avoiding service, knowing where he was, but we couldn't get actual service on him. While he was doing that, the deposition testimony will show, he was meeting with the defendants. He was working with them and putting together their case, where he was a government official that's supposed to be impartial, supposed to be ensuring the integrity of elections, was stonewalling the contestants being able to serve subpoenas. That's very unfortunate, and it goes to the problems that we see in this case and why it's so important that we have true transparency in elections, why it's so important that we have impartiality. The court is going to see, in Clark County, unfortunately that didn't happen, and we have one witness, I believe it's Doe 1, although I'll verify that in a moment, who says that Mr. Gloria was inspecting voting sites with a Biden pen, wearing a Biden pen. This is from a county employee, a whistleblower, came forward and gave deposition testimony in this case. It is difficult for the voters to know that this election has integrity when you have situations like that. Very, very unfortunate decisions like that. Where you have situations where we are in a very short time frame and have a problem getting the evidence that we need in order to bring it before this court, because people know that of that short time frame and think they can simply run out the clock. Nonetheless, even with that, we have given to the court the compelling evidence that we've given the court. Expert testimony from former Secretary of State Scott Gessler that goes into great detail into the the failings of the election administrators, the problems with trying to administer a vote-by-mail system the way it was done. Testimony from poll workers about the lack of any meaningful security for physical and electronic ballots. Data gathered and narrowed in less than a month, showing thousands and thousands of specific incidents of fraud and irregularity. Testimony from technical workers who manage the electronic voting machines that people cast their ballots on. And this is testimony, again, that's Doe 1, right? Doe 1 the Doe 1 deposition is compelling, and we ask the court to pay special attention to it. The Doe 1 testimony shows, and it's supported by other evidence as well, that from another whistleblower, and more evidence submitted to the court, that you had no cybersecurity, no physical security on the voting machines, on these electronic machines that people went to cast their votes when they decided to vote in person, or when they decided to vote early in person, either on election day or early, I should say. And the fact that those discs, in each of these voting machines, you would put a USB disk. And that USB disk was not encrypted, didn't have security on it. And the voting machines themselves were essentially not password protected. And they were hooked up to laptops then where the laptops themselves could have been compromised. And in the middle of the night, what they would do is they would log these disks in and out. Good practice. And the disks had a specific serial number on them. And numerous times, a disk would be logged out with one vote total on it, and logged back in the next morning during the early vote period with a different number on it. Sometimes more, sometimes less. What that means is that literally in the dead of night, votes were appearing and votes were disappearing on these machines. Now, we have tried extremely hard, and the court gave us an order earlier this week that allowed some inspection on the digital devices used in this election, to find out how this could happen. And no one can tell us how it can happen other than the fact, that we know that there wasn't any encryption on the disks. You would plug this disk into a computer, and you could access all the votes on it. You could change totals, you could change columns for the voters. That much we know. And the unfortunate thing is, we can't have access to these machines in such a way that we can inspect them to verify that these machines are doing what they're supposed to do. Instead, the manufacturer of the machines rests on claims of intellectual property for the code and whatnot that they have. That's a problem. When it comes to voting, we can't have people hiding what could be malicious code or bad code. Maybe it's only accidentally bad, maybe it's purposely bad, behind intellectual property. Then having no way to be able to ensure that the results this machine is putting out has any form of integrity with it. So, we know the problem. We can't get to the exact solution because we can't get the full inspection. But what we do know with these machines, what we are sure about, what we have testimony to, is that in the dead of night, votes disappear and votes reappear without explanation. And there's no good explanation for votes being cast on a machine, on a disk that is unplugged from a machine in the middle of the night.
In reference to that issue, what evidence are you specifically relying on? Which specific individual, whatever? I'd totally like to know that.
Doe 1, Your Honor. Doe 1 testified about that, and that there is another declaration that we've submitted to the court from a separate whistleblower that supports that. The declaration is, what exhibit is the second one? Exhibit 62, which is in binder 4, Your Honor.
Thank you.
Your Honor, we've also introduced testimony from people taking advantage of underrepresented communities. Evidence that shows that bad actors executed a scheme of incentivizing individual people to vote. Going to some of the reservations in Nevada and incentivizing people to vote, where it was a very clear tit for tat. You had to show that you voted, and if you voted, you would get things like raffle tickets. And many people were getting cash cards, gift cards, televisions, more.
How many votes are we talking about there?
I thought it was like 500 when I reviewed the information, the deposition, and that. It wasn't a huge amount of votes, though, was it?
Your Honor, we don't know because we haven't been able to get some of the exact discovery on the exact number of votes that were actually counted using that system.
That was your information, 500. So
Correct. 500 is how much we've been able to. I believe that's right, Your Honor. I think that it's that number, and so that is. Of course, some of our numbers are bigger than others. This is a particularly important one because it's at least 500. It's not something that would otherwise be in our care, custody, or control to come up with without more formalized discovery, but we do know what we've submitted to the court on that. That's in clear violation of the law. And in addition, the same campaign that was being used to I understand the wonders of modern technology. Thank you. The same campaign that was incentivizing people to come out and vote in violation of state and federal law, that same campaign was also directly involved in encouraging people to come out and vote for the Biden-Harris ticket. We, of course, don't have information that those people were paid by the Biden-Harris campaign, but it was still a part of show up and vote. We're going to give you something of value, and in several parts, sometimes the same part of the campaign, sometimes separate. Oh, also make sure that you vote for Biden-Harris. This is something that can never be able to stand in an honest election. We have evidence that is more direct when it's tied to the Biden-Harris campaign. Evidence from a whistleblower, Doe 3, of individuals at a Biden-Harris bus, and this bus was close to a polling location, an early vote polling location. And at the early voting polling location, as she was on her lunch break, she would take walks around the center on her lunch break. And as she was on her walk, she noticed unusual activity happening at the Biden-Harris van. She was a poll worker. She knew what ballots looked like. She saw people taking handfuls of ballots, multiple people, and filling them out on the side of the Biden-Harris van. Not one, not two, but multiple ballots being filled out. Everyone gets, again, exactly one vote. No more, no less. There is no reason why anyone at any place would be filling out more than one ballot. And for people to bring handfuls of ballots to one location where they're then, and there's also statutory requirements about when you can help a voter fill out his or her ballot and what you're supposed to do if you do that. In that case, Your Honor, the whistleblower circled back around again and saw them actually putting the ballots into the pink and white envelopes, which of course is the color that she's able to get close and see, that she would know because she's a poll worker, the return envelopes that people would use to return their ballots. You can never do that. There's never an instance where that would be an acceptable thing to do. She reported this. She reported this incident to her supervisor, who called the county, who called the people in the registrar's office, and they were told, oh no, vote harvesting is not illegal. This, of course, is not vote harvesting. Vote harvesting has its own problems, but the legislature has, in its discretion, decided to make it legal. This is vote planning. This is ballot box stuffing, pure and simple. There is never a reason where a person can fill out more than one ballot, and it was happening in this election. That takes us back to the data that we talked about and why the data is so important in this case. This is data that we got from Mr. Camsell as an expert witness, that he was able to testify to a reasonable degree of certainty about what he does in his normal course of work in order to take and compare the list of people who have voted with other lists that are available, so we can actually see if the people are voted are people who are voting legally. The numbers he came up with were striking.
You know, the defendants don't think that the
Camsell all has the credibility or the qualifications to even testify based upon his lack of education, lack of statistical analysis ability, lack of publication, lack of other testifying, it goes on and on and on. So, again, there's an issue in respect to his credibility, under basically the Nevada law. Obviously, Nevada law would look at the hallmark case and whether or not he meets the qualifications, even as an expert. But I'm raising it because the defendants raise it a lot in respect to his testimony.
And it's certainly an important issue for the court to consider is whether he's an appropriate witness. And of course, using hallmark, using the system that Nevada uses to qualify experts. There is always the difference about weight versus admissibility of experts. And it is not the situation where you can only put a college professor on the witness stand or someone in academia to testify as an expert. When it comes to expert testimony, you often look at the experience of the particular individual and what kind of experience the individual has had in coming up with these particular methods. And someone that has worked in data science and analytics for as long as he has is somebody that has that experience, that helps the court, is helpful to the court, not in giving legal conclusions. And much of the questions that they ask Mr. Camsell are just legal conclusions, which of course would never be acceptable as expert testimony. But the method that he actually takes in order to compare one list to another.
He comes up with a lot of different numbers. I went through his numbers and looked at them and tried to understand them. Does he ever make a determination in respect to his numbers where he says X number of these votes would have gone to basically Donald Trump? He doesn't.
No, and let me explain why we can't do that.
Well, doesn't that become an issue though? Because it's very difficult because we look at the two-pronged test in regards to NRS 293.120, A, and then the different ones that you go through. And you have to be able to show the differentiation in respect to the votes. Sufficient in number of votes to get over, I think in this case, 33,596 votes. And he never says that, because I went through that deficit looking for that determination. He just says, these are the things that we think may have happened. We think these things happen that are bad. And I'm not saying he's not right or wrong. I'm just saying, at the end of the day, when you get done with this analysis, we don't know where those votes would have gone. Or if those votes went one way, they shouldn't have gone. There's no ability for him to make that determination reviewing his deposition. At least I took that away from this deposition.
If that were the standard, that you had to be able to tell which contested votes would go to candidate A and which contested votes would go to candidate B,
It would make any election contest impossible.
Yeah, I don't disagree with you. It's just but that's part of the test.
I think that that's not exactly part of the test. Here's where I would disagree with the court on this. I think the test is whether there is enough votes that shouldn't have been cast that would span the margin between the candidates. That's what we look at, and that's because of secret ballot. It's also why, this is another reason why it's so important to have these protections on the front end. Why you have to be able to protect election integrity on the front end. Because short of an election contest that we're doing right now, there's no way to do it on the back end. To be able to tell X number of these votes would have gone for Joe Biden, Y number of these votes would have gone for Donald Trump. Once a vote, there's two different ways in Nevada this year that votes are cast. They're cast on an electronic machine or they're cast in the mail ballot. Once the vote, if it's cast by mail, is taken out of its envelope, that is something we call separation. And because the envelope includes all the voter information on it. And what is supposed to be done then to provide for security is that envelope and that ballot never again will meet. They can never be matched back up to each other, because if they can be matched up to each other again, it's not a secret ballot. So once that ballot comes out of the envelope and it goes into the voter pool, if it's a poisonous ballot, it's poisoning the entire pool. And so, yes, there is no way for us to be able to tell which of these people voted for which candidate, because we hold the secret ballot so sacrosanct. But that's why you should not read the contest statute to be able to say that you have to tell how many bad ballots went for candidate A and how many went for candidate B, because if you do that, you make an election contest impossible. Mr. Kansel's long experience, does allow him to identify specific voters to a reasonable degree of certainty. And he took his various universes and found that over 8,111 voters voted from fake addresses. 15,681 voters voted from vacant addresses and commercial addresses. This is especially important. This is these irregularities that we talked about. You can't do that. You can't vote from a fake address. You can't vote from a vacant address. You can't vote from a commercial address, because it has to be where you live, because that is where you are represented. You're represented where you live. 1,506 votes from dead voters. 19,218 votes from non-Nevadans. And particularly striking is 42,284 votes from double voters. That number right there is more than the gulf between Vice President Biden and President Trump in this case. Now,
We have about 15 minutes
More to go.
I understand. I've run more than Dan.
35 minutes. I just thought I'd give you a heads up.
Thank you, Your Honor. And I've also been made aware by my co-counsel. And I'm going to leave it. I'm going to wrap
up at this point, and then I'll be back for The double voting happens because the voter rolls aren't clean, and we have evidence that we've submitted to the court where people, good people, honest people, have taken that and say, look, I've got 2 ballots here. You know, maybe it's one in my maiden name and one in my married name. When you don't clean the voter rolls, stuff like that happens. Honest people do what happened here, in some cases bringing them to us, not voting them, destroying them, whatever it might be. But in a presidential election, perhaps this presidential election more than most, passions were high. People felt very strongly. And we have 42,284 instances of people voting twice. We have the poll that we've submitted showing that of the people who submitted mail votes, approximately 1% of those people say they didn't cast a ballot at all. Again, something that without the tools of a prosecutor, it's one of the few ways that we can actually test that. So people are taking other people's ballots, and there's been stories about that has happened where people are having their votes specifically stolen. And people, you know, that may wish to abstain and not vote at all are voting because somebody else decides to vote for them. Your Honor, every single one of these instances that we've identified has resulted, again, in the votes of honest Nevadans being disenfranchised. The only thing to do with this, to avoid the debasement and dilution that comes with the vote fraud and irregularities, is to grant the contest and to strike the Biden voters from representing Nevada in the Electoral College. We understand that this is an unusual situation, but what we can't do is turn a blind eye to voter fraud. We're going to keep being the beacon of representative democracy of the world. When it goes bad, and here it went bad, we can't just turn a blind eye to it. That's not what we do in America. We make it right. We are asking the court to make it right. And the way to do that is to make sure that improperly elected electors don't represent Nevada in the Electoral College.
I reserve the rest of my time.
We're going to just take a short break, about 10 minutes. We'll come back and proceed on that basis. Thank you. Mr. Hamilton, don't go anywhere.
They're having trouble hearing the podium mic next door. Oh, really? Sounds good to me. Oh. How you doing?
We're going to use some podium, 7 feet, the table.
Yeah.
Look at the attorney table and that. We'll have a problem here.
Yours. Yeah, it just says not connected to the server. So we the source just needs to be restarted for make sure when you post your story, you put exhibits so your readers can't do it right away. No, I give you a hard time. Compare me with that one, put it on the internet. You know, he basically declared, right? He was talking to the Las Vegas Chamber yesterday. They asked him if he's going to run for governor. Yeah, but into it. You know him. That's basically him declaring, yeah. That's what it's all about. You go past it. I actually spoke to some stuff. That's how it is. Well, we won it though, years ago. Check it out. If you look at the motion, the whole legislators that we endorsed, we primarily endorsed, they all really seem powerful. So proof to some. Worse if you're speaking.
Very good to hear. Yeah, I'm okay with that, a jury trial. Well, any issue.
If you're afraid,
He's a great guy to work for. Seems like that. Yeah, he's awesome. I've been called and all we've been doing right around is practically show
I guess really doing like in work. Where's that coming from?
In fact, he told me that. You're going to they're in a big meeting.
Good seeing you. Such consistency. Yes, sir.
But when it goes through all of them, you can see from the table. Very, very much. Very, very much. Council, you ready?
I'm ready.
All right.
We're back on the record with respect to case number 20-OC-00163.
Mr. Hamilton, are you ready to proceed with your argument?
I am, Your Honor.
Go ahead, sir.
Thank you again. It's Kevin Hamilton. I appreciate that the court has set 60 minutes per side for argument. And not to test that limit or the court's patience. On November 3rd, 2020, the voters of Nevada and the nation as a whole elected Joe Biden as President of the United States. In Nevada, the margin was 33,596 votes, as Your Honor noted. Those results have been carefully canvassed, audited, and certified by county and state officials, including the Nevada Supreme Court. 2 weeks after that election, on November 17th, the contestants filed their statement of contest, and the contest seeks breathtaking relief. An order from this court overturning the election and declaring President Trump the winner in Nevada and certifying contestants as the state's duly elected electors. Or in the alternative, holding that the November 3rd election be annulled and enjoining Nevada from certifying any electors from the state of Nevada, entirely silencing the votes and voices of 1.4 million Nevada voters in the selection of the President of the United States. It's difficult to imagine a more shocking and fundamentally undemocratic act than to ask a court to overturn the expressed will of an entire state simply because the contestant's preferred candidate didn't win the election. No court in the history of the United States has ever entered such relief. Now, one would imagine that any contestant seeking such unprecedented and breathtaking relief would approach this court cautiously. As the United States District Court for the Middle District of Pennsylvania noted just 2 weeks ago, one might expect the contestant seeking to overturn the results of a presidential election would come formidably armed with compelling legal arguments and factual proof of rampant corruption, such that the court would have no option but to regrettably grant the proposed relief despite the impact it would have on such a large group of citizens. Close quote. Not these contestants. It's difficult to imagine that even they take this claim seriously. From the start to the jumbled end, this contest appears to be nothing more than part of a larger extrajudicial effort to disparage hardworking state and county local officials election officials across the country and cast doubt on the outcome of elections, all in service of some larger political agenda. Nothing about the contest even remotely warrants the relief the contestants seek. First, from the very outset, the statement of contest falls woefully short of satisfying the requirements of NRS 293.410, the raising cognizable grounds for an election contest. The claims relating to the Clark County use of the Agilis machine have been considered and soundly rejected by several different Nevada courts, including this court, and are thus barred by the doctrine of issue preclusion. And it's a claim that could and should have been brought long ago, so latches also bars the claim. And none of the claims alleged in the contest actually fall within the very limited grounds enumerated by the contest statute. So the contest stumbles at the very courthouse door, and for that reason we move to dismiss the case. But second, if the court even considers the contest on the merits, the closer one examines the claim and the supposed supporting evidence, the more the case simply falls apart. Contestant evidence on examination is built on nothing more than speculation, conspiracy theories, and a fundamental misunderstanding of the electoral process in Nevada. None of this comes close to satisfying contestants' heavy burden of proof. None of this is sufficient to overturn the results of the election. And none of this justifies the astonishing relief sought by the contestant. So let me start with the bases outlined in the motion to dismiss that we filed on November 23rd. First, to the extent that the contestants based the contest on Clark County's use of the Agilis machine or its failure to allow meaningful observation, both of those issues have been raised multiple times, fully litigated, and soundly rejected by this court. In Krause versus Sagatsky, the court considered these issues over a 10-hour evidentiary hearing, complete with live testimony from 9 witnesses and legal argument from counsel for the contestant himself, Mr. Banal. Judge Wilson considered and rejected those claims in a thoughtful 14-page ruling. It's true he found a lack of standing, but there were alternative bases for his decision. And the contestants here as Trump electors are obviously in privity with the plaintiffs there, which was the Trump campaign and the Nevada Republican Party, and are thus bound by the decision there. So all the factors we've submitted for issue preclusion. But even if the claim weren't technically barred by issue preclusion because of the Krause decision, that decision is certainly persuasive authority for the proposition that nothing about the Agilis machine or how it was used by Clark County was even remotely improper. And indeed, since the election, 3 different district court judges in Clark County, Judge Atkin in the Rodimer versus Gloria case, Judge Sperman in the Marchant versus Gloria case, and Judge Hardy in the Becker versus Gloria case, as well as Judge Gordon on the U.S. Court of Appeal, the United States District Court for the District of Nevada, have flatly rejected similar claims. None of them have reached a contrary conclusion. Second, contestants' challenge to the Clark County use of the Agilis machine is barred by the doctrine of latches. The county's purchase of the Agilis machine was not a secret. It was reviewed by and even subsidized by the Nevada Secretary of State's office. Contestants could have and should have raised any concerns that they had about the use of that machine literally months ago, prior to its deployment in the county. Indeed, the county used the Agilis machine during the June primary. No controversy, no complaint, no issue. Contestants could have and should have raised any claims they had then, prior to the use in that election, or at the very least in the ensuing 5 months before the general election. But instead,
Hamilton, if you can hear me, we lost you.
Judge, the phone disconnected.
Huh?
The phone disconnected.
The phone got disconnected. If you hang on one moment, we'll get it.
Please enter your app, followed by the pound. To enable audio control, please enter your audio PIN, followed by the pound.
See if Mr. Hamilton can hear you.
Can you hear me?
Again, you're
Thank you. We can hear you again. If you can go back and start, I think you were kind of at the end of the Flashes argument. Go ahead.
Right, thank you, Your Honor, and I apologize for the technical issues on it. Hopefully the technology god will be with us for the rest of the argument.
Well, we aren't sure what happened, but go ahead. I apologize to you if it's on our end.
All right, thank you. The point is that the contestant sort of raised the complaint about the use of the Agility machine well prior to the general election and well before hundreds of thousands of ballots had been processed by that machine, allowing them to sandbag more than 1.4 million Nevada voters by waiting until after they voted and after the votes have been counted and certified by county election officials, and then asking this court in one judicial wave of the arm to reject them all is the very definition of prejudice. And so for that reason, the doctrine of lapses would preclude relitigating this claim again. And then finally, the claim fails for failing to comply with Nevada law. The Nevada election contest statute requires that the ground of the contest be alleged with sufficient certainty to inform the defendant of the charges the defendant is required to meet. That's NRS 293-410 sub 1. But the claims in this contest are anything but clear and certain. They can hardly be called anything but vague and undefined.
Well, let me ask.
The contest asserts very.
Can I ask you a question in respect to that? Obviously, if you look at Nevada Rules of Civil Procedure 8A, basically we're a notice pleading state. And I guess the question I would ask, I understand your argument in respect to sufficient certainty, but if we're a notice pleading state, and you go back and you read the statement of claims, do I make correlation over to the Nevada Rules of Civil Procedure in light of the statute, or can I just look at the NRS 293.410, or don't I have to also look at basically the Nevada Rules of Civil Procedure a little bit to correlate things?
Well, Your Honor, of course, the Nevada Rules of Civil Procedure would be applicable to the extent that they're not inconsistent with the election statute. But election contest is a unique proceeding that's defined by Nevada law. And where the statute requires, calls out a specific pleading standard that is sufficient certainty, then of course that would trump, by the very Latin maxim counsel just described a moment ago, that would trump the generalized application of the Nevada rule. And the point here is because a Nevada election contest is such a short time frame thing, you don't bring this kind of a lawsuit unless you have the evidence to make a claim with sufficient certainty to inform the defendant of the charges. So it's not enough to assert categories. You have to name voters. And that's exactly where this complaint fails. It fails to identify even a single voter who, in any of these categories, who cast an unlawful vote. It fails to allege with certainty which voters voted twice, which they were at which voters voted after moving out of state, or even for whom those alleged ballots were cast, or whether they even voted in the presidential election. Now, I'm just going to pause there. Counsel makes the argument that, well, golly, you can't prove that because the envelopes and the ballots are separated. That completely misunderstands an election contest, Your Honor. You're alleging an individual. John Smith voted twice. You have to name John Smith and prove for whom he voted. That's not impossible. In fact, in 2004, in 2005, there was an election contest over the governor of the state of Washington. It's a 2-week trial held in Wenatchee, Washington. I represented the governor in that case. And in fact, there were 4 depositions of 4 voters, in that case, all convicted felons who should not have been voting in the election. We took their deposition. Of course, you can ask them how they voted because they were illegal voters. They broke the law. They committed felonies by casting those ballots. So it's easy to do that. You just have to do it specifically because that's the only way this court has an evidentiary record to make a conclusion, to reach a conclusion that illegal votes were cast and for whom they were cast and by how many. And so there's a pleading problem at the front end of this case and an evidentiary problem at the back end. Let me finish on the front end. Having failed to identify specifically and pleaded specifically, the claim failed as a matter of pleading, and that is very important to a contest to action, and so the case should be dismissed at the threshold. But if the court goes on to consider the contest on the merits, the result's the same. The contest fails as a result of an utter collapse of proof. The contestant's case is simply a calamity, and the contestants barely contend otherwise. Ink is cheap, and contestants spill a lot of it attempting to make up their patent lack of admissible evidence with enthusiasm and overstatement. But their zeal rather dramatically outstrips their evidence. And in court of law, it's evidence that counts, not tweets or social media bluster, not hearsay or speculation. It's evidence, and that's what's missing in the record before the court. I just listened to counsel talk for the better part of 40 minutes with very few references to any actual evidence before the court. And so I think it's worth taking each specific claim in turn. The first is the Agilis machine. The contestants claim that Clark County violated the law by using that to sort ballots and verify signatures. That seems to be an invocation of NRS 293.410.2 sub F, which allows a challenge if a contestant can prove that, quote, there was a malfunction of any voting device or electronic tabulator, counting device, or computer in a manner sufficient to raise reasonable doubt as to the outcome of the election, close quote. Again, that's 410.2 sub F. This is not a new allegation, Your Honor. As I mentioned earlier, no fewer than 5 Nevada courts have considered this claim. Judge Wilson held that 10-hour hearing to explore it in Krause. Every court, state and federal, has rejected this claim without exception and without hesitation. And it's not actually all that surprising. The Agilis machine is widely used by some of the largest counties and metropolitan areas in the United States. Cincinnati, Ohio, Tallahassee, Florida, Pueblo County, Colorado, San Francisco, California, Salt Lake City, and dozens of others. Counties where Democrats are in charge, counties where Republicans are in charge, most importantly, counties where Americans are in charge. Contestants appear to raise 3 separate challenges to the machine. Each one is there. First, they allege Clark County should never have used it at all, and that its use in processing signatures violates Nevada law. You heard that argument just a moment ago. That's perhaps the easiest to dismiss. AB 4 specifically authorizes county elections officials machine was properly utilized because they set the threshold at 40 rather than using the threshold setting of 50 that the machine is set on when delivered from the manufacturer. But that claim, too, has been thoroughly examined and thoroughly rebutted. First, and it's before you, the testimony of Jeff Ellington, the president and chief operating officer of Runback, the company that makes the Agilus machine. We took his deposition and transcript is before you. He testified that the company recommends that elections department threshold set using a test deck of sample ballots to ensure that the machine accepts only obviously matched signatures. Jeff Allen. Second, Joe Gloria, worked for the registrar of voters, testified that's exactly what he did. Used a test deck of ballots to ensure that only obviously matched signatures were accepted and that all other ballots were rejected by the machine and subject to human use. The result is 30% of the ballots were accepted by the machine and 70% were reviewed by election department personnel. And maybe most strikingly, contestants' own expert mentioned just earlier in this very courtroom, Scott Gessler, admitted on cross-examination in his deposition that Clark County's use of the Agilus machine was entirely proper and even consistent with what he termed best practices. That's Heston's expert. Against that clear, specific, and undisputed evidence, contestants offer literally nothing. They stand empty-handed without any evidence to suggest that there was anything wrong with Clark County using the Agilus machine or how it was adjusted or how it was employed. But the claim simply fails for want of proof.
Mr. Gressler made a comment in his deposition, something about to the effect that 40%, which is what Clark County used, was appropriate. Is that correct?
That's exactly right, brother. In fact, he calls it best practice. The third attack on the Agilus machine relates to the Clark County database of exemplar signatures, which in some cases includes signatures from the Department of Motor Vehicles that were of poor quality. Specifically, the contestants contend that the Agilus machine requires images to be at least 200 dots per square inch, or DPI, and that the DMV signatures were only 100 DPI, and thus unreadable. So this fails for the same reasons, really. Mr. Ellington, again, the president of Runback, the manufacturer, confirmed that while it's true the Agilus requires a 200 DPI signatures to match a signature, he testified that if the machine couldn't read it because it was a poor quality exemplar, then it rejected the ballot, which means it defaults to human review. He emphatically testified that the Agilus would not match a signature when the exemplar was low quality. And Mr. Gloria testified to the same thing. If the Agilus machine couldn't find a high-quality image against which to match the signature on the envelope, then it would reject the envelope for human review. And again here, contestants have no contrary evidence. There's no countervailing expert, no technical operator, no other counties or states operators testifying that something was amiss here. Nothing but bald allegations and speculation. They offer hearsay evidence from people who thought that certain signatures looked strange. And I don't doubt that people could have differences of opinions about signatures, but that's not enough by a far cry to sustain contestants' burden here. So the Agilus machine claim fails from start to finish, top to bottom. There's simply nothing there. And that, of course, is why every court to consider the claim has rejected it without exception. So whether you consider the case, the Krause case, to bar the claim for issue preclusion, or you bar the claim based on the failure to raise it sooner, you look at the merit, there's simply nothing there, Your Honor. The next category of claims advanced in the contest is legal improper votes. Under Nevada law, an election can be contested on the grounds of, quote, illegal or improper votes that were cast or conversely, legal or proper votes that were not counted. And in either case, equal to or greater than the margin between the contestant and the defendant, or otherwise in an amount sufficient to raise a reasonable doubt as to the outcome of the election. That's NRS 293-410-2 sub C. And Your Honor, this is where the wheels truly come off the train. Plaintiff stands before the court with no evidence of any illegal votes, much less evidence of which voters they contend cast those ballots, or even more fundamentally, for whom those ballots were cast. They fall far short of demonstrating 33,596 votes, the margin. There's no evidence to support these allegations, no specific evidence, no specific voters or ballots, no knowledgeable witnesses with relevant and admissible testimony, expert or otherwise. So first they contend in the contest that same-day registrants were permitted to register by providing mere proof of Department of Motor Vehicle appointments rather than photo ID, or were allowed to cast provisional ballots even if they couldn't satisfy voting requirements, or that provisional ballots were counted even if not cured, or that mail ballots were counted from voters who didn't cast them. But there's no evidence to support any of that. The contestants offer a handful of witnesses to support the claims, but they largely concede in their depositions that they can't, that it's speculation. Doe 3, for example, testified that voters who only provided proof of DMV appointments were given provisional ballots, and conceded that she didn't know how many ballots fell in that category, whether those ballots were counted, couldn't identify the names of those voters, couldn't identify whether those voters had voted in the presidential election, or for whom those ballots didn't count. Doe 2 testified that some signatures looked suspicious and questioned out-of-state ballots, and felt that supervisors had unrestrained access to ballots, but agreed, in her words, in her deposition under oath, it's all just speculation. Doe 1, which was mentioned by counsel a moment ago, I would encourage the court to read that deposition with particular attention to page 66 and page 77. Page 66, Doe 1 admits that there's no evidence of any difference between the paper audit trail and the vote totals on the machine. At page 77, Doe 1 admits that he's not aware of anyone tampering with any of the USB drives. The contestants allege that no less than 500 provisional ballots were counted without the issues that rendered them provisional having been resolved. But they provide no evidence that this actually occurred. You, Your Honor, and I, and members of the public are left to guess who these 500 voters were. Joe Glory was asked about that allegation in his deposition. He specifically denied it. That absolutely not. Provisional ballots were treated in accordance with the rules, and only those that meet the requirements of Nevada law were counted. So that's the specific evidence that they come forward with, and it fails rather dramatically short of the mark.
Let me ask you.
They then fall back.
Let me ask you one question. One of the things that they raised in their brief was that Joseph Gloria made a statement to the Clark County Commission on November 16, 2020, that his staff discovered discrepancies that we cannot explain and cannot remediate without a recount. Are you aware of that statement?
I am, Your Honor.
Can you explain that in the context it was given, or maybe it's taken out of context? I found that interesting.
It is, Your Honor, you know, the truth of the matter is, and it's not unique to Nevada, it's not unique to 2020, and it's not unique into a general election. Every election will have minor anomalies and irregularities that just happen. So it's not like counting a universe, when you're counting a universe of 1.4 million ballots, there are instances in which there are minor discrepancies in the numbers. For example, in polling places, in the United States, we rely on volunteers and temporary workers to staff our polling places. That's how we do it. We don't have to do that. We could have a federal election organization, but in the United States, historically, we've relied on citizens to come forward. And a lot of those people work long, a lot of those people are retired. They're your father, your mother, your uncle, your brother. Those are the people that run our polling places, make our democracy work, and they work long hours. And at the end of the day, they have to fill out ballot accountability sheets. How many ballots did you have on hand? How many were spoiled? How many were voted? And you know what? Sometimes they make mistakes at the end of a 14-hour day. Those are the kinds of discrepancies Mr. Gloria was referring to. Those are the kinds of things that happen in every election. But you know what? They're not proof that anybody voted illegally. That's a much more serious allegation, and it requires much more serious proof. So Mr. Gloria's statement, I think, is being blown way out of proportion for what it actually was. Did that answer your question, Your Honor?
Yeah, thank you.
The second way they approach this is with expert testimony, and particularly Mr. Kamsall, and they use a sort of a broad brush category approach, or Mr. Kamsall refers to them as universes. Universes of ballots improperly counted. So he's telling people, there's some background, I'm not sure what that is.
We don't know. You're fine.
Okay. Mr. Kamsall's analysis collapses upon even minimal scrutiny. He is hardly a credible expert. As I mentioned earlier, he spent his entire career as a political operative for the Republican National Committee. Admits that he didn't actually perform the data matching upon which his analysis depends. He doesn't know the rate of false positives. He doesn't know the error rate revealed in that exercise. He claims that he validated his work, but didn't supervise or direct those efforts, and has no idea what that work demonstrated or the error rates they uncovered. And it's based on that testimony that contestants claim that thousands of Nevada voters committed felonies, voting twice, voting illegally after moving out of the state, or cast ballots in the name of dead voters. But Mr. Kamsall's analysis doesn't begin to prove that. For starters, Nevada voters who move out of state but maintain their residency are most certainly entitled to vote in Nevada elections. College students, for example, military personnel, citizens seeking medical treatment out of state, citizens assisting agencies in times of need, citizens spending winters or summers in vacation properties, serving in Congress, or living temporarily out of state for a million other reasons. Mr. Kamsall can't control for any of that, and he doesn't, and he admits it. Voters who passed away obviously can't vote unless they cast their ballot prior to their death. But Mr. Kamsall offers the court no evidence with respect to the date of death of the voters he identifies here. More fundamentally, he doesn't in fact identify even a single voter whose ballot was cast after he or she passed away. Not one. And he claims that there are thousands. You'd think he would attach them to a declaration that he would come forward with a report that he'd name even one. The same is true of Mr. Kamsall's allegations of voters who voted twice. He didn't do the critical data file matching, can't testify to the match rate, the false positive, or the error rate. This is precisely why courts across the country have routinely rejected this sort of slipshod analysis and voter registration cases. This is the ones I'm familiar with, Your Honor. I dare say that in an intellectual property or technical case, Mr. Cancel would never be admitted as an expert. But perhaps most fundamentally, the contestants nowhere identify these supposed thousands or even tens of thousands of illegal voters. They allege in their statement that 15,000 Nevada voters voted both in Nevada and in other states, but they don't identify a single one. I go back to my very first point, Your Honor. This is a failure to identify with certainty. They identified a specific voter, sure, then the defendants or anyone else could go at that voter and determine whether they in fact had cast a ballot in two different states. A categorical accusation doesn't make proof in court. Same thing with respect to the allegation that votes arrived after the deadline for mail ballots were counted. Which one? They allege that 500 votes were submitted at polling places by individuals other than the proper voters, again, without identifying a single one. They allege that letter carriers violated USPS policies by delivering ballots to homes where voters didn't live, but they don't identify any of them. Your Honor, this is trial by allegation, not proof. And it falls far short of the heavy burden Nevada law places on those seeking to contest the outcome of a certified statewide election. Voting fraud in the United States is thankfully vanishingly rare, as Professor Herron testified. Yet contestants stand before you and boldly allege the wildly implausible that over 42,000 Nevada citizens committed felonies by voting twice in this election. 42,000. You'd think that anyone leveling that sort of a charge would have powerful proof. But contestants don't. They can't even name them, or perhaps they don't want to name them because of fear of liability of accusing somebody of a crime that's obviously defamatory. They can't prove that any of those individuals even voted in the presidential election, and they certainly can't prove for whom those ballots were cast. This is an utter failure of proof on every level. Charitably, one might call it junk science, unreliable on its face, and offered by an expert who is no such thing. But even taken at face value, it fails to prove that which Nevada law demands, that illegal votes were counted in an amount equal to or larger than the margin between the candidates. So again, the claim fails for want of proof and should be dismissed on that basis. The third category involves allegations of misconduct by the Biden campaign itself. Contestants suggest that various groups or individuals affiliated with the Biden-Harris campaign engaged in misconduct, but they provided prove that allegation. Doe 3, for example, claims, and you heard a rendition of this just a moment ago, that unnamed and unidentified individuals gathered around the Biden bus in a parking lot of a polling center in broad daylight to engage in ballot stuffing. But in addition to being patently ludicrous, that witness admits to having no idea of whether these supposed votes or ballots were ever cast, let alone counted. That admission is devastating to this claim. And the contestants point to the Nevada Native Vote Project, which undertook voting drives this year, and argued that the Biden campaign bribed voters. But the only link they have between that group and the Biden campaign itself are masks, t-shirts, and signs. Is not implicated and is not responsible by anything a supporter does while wearing his or her t-shirt or hat. And in any event, or maybe the most fundamentally, they offered not a single witness who observed this event or could authenticate their photos. Not a shred of evidence to suggest that anyone was offering anything of value to manipulate a vote. And not a single thing that would indicate those individuals were acting on behalf of the Biden campaign. The entire allegation is simply a meritless attack on an organization that promotes Native American voter turnout without any basis in either fact or law. The last grounds that, quote, the election board or any member thereof was guilty of malfeasance, quote, that's NRS 293-410 sub 2A. There's no evidence to support this broad and entirely unwarranted attack on Nevada's hardworking election officials. First, the contestants claim they were not granted meaningful observation opportunities, but they utterly failed to demonstrate this was willful misconduct, much less anything more than routine regulation of observers during the canvassing of an election. And regulation that was particularly important during a raging local pandemic. That's precisely why Judge Wilson in the Krause case rejected the same claim. And the only other allegation of malfeasance is use of the Agilus machine. And that fails for the same reason mentioned before. State law authorizes the processing and counting of ballots by electronic means. This isn't malfeasance, Your Honor. This is nothing more than regular, routine, and professional administration of this election by Joe Gloria and his team at Clark County and all the election administrators across the great state of Nevada. Mr. Gloria is one of the most experienced and highly respected election administrators in the entire country. So let me just wrap up and I'll stop. Last week, the Third Circuit wrote, voters, not lawyers, choose the president. Ballots, not briefs, decide election. That's not something that a court should have to remind litigants. But since the election 1 month ago, we've seen the same pattern all across this country. Baseless lawsuits filed by plaintiffs who simply cannot accept the fact that their favored candidate lost the election to Joe Biden. But that's the decision the people of the state of Nevada made and are entitled to make. And that's a choice that can only be reversed or thrown out by this court on the very most powerful of showing with clear and overwhelming evidence of widespread fraud, malfunctioning machines that in fact distorted the true and accurate vote totals, or proof of official malfeasance. Simply put, breathtaking relief demands breathtaking evidence. But contestants stand before you with nothing of the sort. This court has indulged contestants at every turn, allowing 15 depositions on extraordinary court notice, compelling examination of sealed election materials, entering protective orders allowing witnesses to testify anonymously, and otherwise largely allowing contestants free range to collect whatever evidence they wish in whatever manner they sought. It's now clear that despite this flurry of last-minute activity, it was all for naught. Contestants are bereft of evidence to support their outlandish claims, and instead they offer hearsay that even on its face doesn't support their claims. They offer big numbers, but without support, without names, and without proof of any specific illegal ballot being cast. Not one. None of this is remotely sufficient to justify this contest, much less the jaw-dropping invitation to this court to overturn the expressed will of 1.4 million Nevada voters. This election was fair, the votes were counted correctly, and Joe Biden won. It's time for the contestants to accept that, and it's time for this meritless case to come to an end. So with respect, Your Honor, defendants ask this court to dismiss the contest without further proceeding, to enter judgment for defendants so that Nevada may have its voice heard when the Electoral College meets to vote for and elect the President of the United States. Thank you for listening, Your Honor, and thank you for allowing me to appear remotely. I appreciate it.
Mr. Canal, I think you have about 10 minutes.
Your Honor, could I ask the court just for some indulgence for another few minutes to put together our reply?
As long as we don't lose Mr.
Hamilton, go ahead and take a short break. Thank you.
Thank you very much, Your Honor.
All right.
Back on the record with respect to case number 20OC00163. Mr. Hamilton, can you hear me?
Yes, I can, Your Honor. Thank you.
Thank you. Now, you want to make your final comments, and of course, it's better to pick up on the mic if you just stay seated, so it's no disrespect to me or anything else, and I won't take it as just being disrespectful.
Thank you.
And I won't hold it against you, so.
I appreciate that, and I thought with the mic being at this level, it might be easier, but I appreciate the court bringing that up. Your Honor, this is a breathtaking case, and the evidence that we put forward is breathtaking, and there's no other word for it. I want to discuss some of the items that opposing counsel brought up in his argument. Talking about how ballots decide elections, and that is the way it's supposed to be. But there is nothing more at the heart of our representative democracy than one person, one vote, and limiting elections to the citizens of that state. Only legal vote should count, but every legal vote should count. And in order to make sure that we are in a system that promise is kept, we make sure that there's meaningful observation. The record is clear, and you can look at does 1, 2, 3, almost all the does 1 through 7, to see the failings that happen in transparency. Transparency is not political. Transparency is something that is necessary for us to have a democratic election, to have integrity in that election so that we know that it is the candidate chosen by the voters that is the one actually elected. As far as the pleading status go, when you read the statute and the specific requirements of the statute, and the part of the statute they are citing is saying that the contest is not normally supposed to be struck for lack of form, it would make no sense for that sentence to be read as increasing Nevada's notice pleading requirements. It was read to put them on notice of the claims. It did just that. The contest went through and did point out and gave notice for everything we would bring up to the court. The statute, we met and see the statute as much as they may wish, the defendants may wish, to add to that requirement. Nevada law does not. Likewise, they have tried to add to the requirement of Nevada law by requiring us to supposedly put in the very specific voters that we think cast unlawful votes. Now, of course, they objected to any depositions. They objected to 15 depositions. We certainly couldn't take 40,000 depositions. We couldn't take 130,000 depositions. We put forward the evidence, and with our data scientists and putting into the record the data, much of the data that was relied upon, we have shown exactly the methodology used to prove the unlawful voters. And the defendants may certainly want to wish to raise the bar more than the legislature in Nevada did, but they should not be allowed to do so. In fact, it's quite honest that they can't attack the data itself. So instead, they try to attack the data scientists. And they have a deposition where counsel testifies a lot about what counsel may wish the data scientists to the things like error rates. But of course, they have no actual testimony that those error rates are something that would affect the result. Even though Mr. Kamsel provided the exact methodology and the exact databases that he used to do the matching, so that they can recreate it, so that they can go through and test his conclusions, they bring nothing to say that those conclusions are wrong. And specifically, and it must be pointed out, that the most striking number is the over 40,000 people that voted twice. And the best response they can come up with that is, wow, that sounds like a really high number. It must not be right. But when you have the situation that we have here, where ballots are being sent all through Nevada, and often more than one ballot to a person, and often to people who have changed their names because they've gotten married or for other reasons, we see that in the passion of the moment, people would vote twice. And that is why that number, while striking, is important. Mr. Kamsel used and explained the methodology that he uses in his profession and he has used for well over a decade. He's used it in political data when he does it. He's used it not for purposes of being an expert witness in political data, but to make sure that when using a campaign, or when executing a campaign, they have the information they want to have on voters. That this is the methods they use. He's also used it on behalf of corporations. He testified to that in the deposition. It has to be something that is testable. The deposition, he goes into great length, the methods he uses to come up with these, and so that he can come and form his conclusions to a degree of reasonable certainty. He's met the standards of being an expert, and any other, met and exceeded them. Any other arguments they have simply go to weight, not to the admissibility, and the weight should be quite large, being that their attacks on the data themselves are quite honestly weak. Regarding Doe 3, I'm sorry, regarding Doe 1, they said that there was no evidence that Doe 1 actually saw people changing votes. This is the very nature, this is probably the best example I've ever seen of circumstantial evidence. When we talk about circumstantial evidence, and if we're going to try to explain it to a law class, this would be the example you use. You don't actually see somebody changing the votes, but at night it has one number on it, in the morning it has another. Circumstantial evidence that sometime in the night something happened to change those numbers. That is circumstantial evidence, and that is striking. They talk about Doe 3, and they can't impeach her credibility. They can't impeach what she saw. They just said that it's crazy that it happened. It is crazy that this was happening in this election. It is so unfortunate that this election was administered in such a way that it was ripe for fraud, such as people packing the ballot box. And they say that they don't know that that those ballots that she saw were cast. Well, of course she didn't follow them to mailboxes. She didn't see what they did. But she saw them putting them into the return envelopes. And when she put that, and that, of course, there's no reason for someone to fill out a ballot, put it in the ballot return envelope. There's no good reason to do that. When you're stuffing ballot boxes, it's clear. That, again, may be circumstantial evidence, but it's striking evidence. And of course, the circumstantial evidence is worth no less weight, especially not with someone whose credibility is so strong. Your Honor, the arguments they make on the Agilis machine, the most important thing about the Agilis machine is something that they can't answer, and that's the fact that the use of it just wasn't authorized by the statute. And then you take and you look at the other evidence of what happens as a result of that. Not just as a result of the Agilis machine, but as a result of the people that were hand matching signatures. Of course, you see in the evidence, the machine was matching about 30% of signatures, and it took human beings to match about the other 70%. But there's all this pressure. You see it from DOE 2, you see it from DOE 3. There's all this pressure to push through the signatures in order to just authenticate them. You see evidence of stars and shapes being used to authenticate a signature, and when a poll worker then takes and brings to their supervisor's attention that says, this is a star, it's not a signature, they're told, push it through. And when you see such a low error rate on the signature matching, you understand why it is so critical that there was not a robust effort to match signatures. They were putting more emphasis on their employees to get it done quick than to get it done right. And if you want an election with integrity, if you want an election that you know that the person with the amount of votes at the end that's being reported is the person who had the most legal votes cast for them, you have to make sure it's done in a way that ensures integrity. And the evidence is they failed to do that. They wanted to push it through. There's evidence time and time in these declarations, and reading the declarations of the whistleblowers and the depositions of the whistleblowers is so critically important. In 1 month, we have put together striking evidence that because of the lack of transparency, because things were rushed, this election was unfortunately stolen. The court asked the question about knowing who voted for who. Well, we know that the vast majority of the problems came from Clark County. We know the vote difference between the two candidates in Clark County. That would be one way to reach that conclusion. We also know that all the evidence of fraud that we brought to the court's attention, all the evidence of fraud that we know of in Nevada, has only come from one side, the Biden side. We cannot turn a blind eye with striking evidence like this. We cannot allow an election to be stolen. We cannot pretend that these voter irregularities and this vote fraud didn't happen. We ask the court to grant the contest. We appreciate the court.
Hamilton, do you have any final comment?
No, Your Honor. I think the case is properly submitted for you. We ask that the case be dismissed. Thank you.
Thank you. Well, first of all, given the time constraints involved in this matter, I'd like to thank the parties for their briefs, their arguments, their excellent arguments, and respect that. I know this wasn't an easy case by anybody in respect to contestants or basically defendants, given the short time and the period in which it was involved. And again, the court tried to accommodate everybody as quickly and possibly as I could in respect to all the issues and motions I was getting. And I tried to rule as quickly as I possibly could, considering all the other matters going on with the court, to be honest with you. Again, given the nature and importance of this
The court would like to review the evidence provided in light of the arguments made. To certain evidence records which I would like to verify and take a look at. To be honest with you, the court orders each party to provide a proposed order which includes findings of fact, conclusions of law, and a decision by 10 a.m. Tomorrow morning for the court's consideration. Now, I picked that time because it's Friday, 10 o'clock. It's the court's intent to get the decision out so that there's time to go to the Supreme Court if anybody wants to go to the Supreme Court in respect to this particular matter. Again, it's most important that we look at the reliable, credible evidence and the rule of law looking at NRS 293.410. And again, and this comment goes to primarily to the defendants. It's the court's preference to really decide this matter on the merits, not on just dismissing based upon a claim that basically there was not sufficient certainty alleged in respect to that. I'm not saying that's not a valid claim or not. It's just my preference when you do your findings of fact and conclusions of law that you go through the merits more than anything. So again, thank you on behalf of the court. I appreciate it very much. Thank you.
Yeah.